Good evening. It gives me great pleasure to welcome everyone, students, faculty, alums, trustees, staff, and distinguished panelists and friends to this remarkable gathering here at Brandeis University. I want to welcome in particular some of our special guests, Massachusetts Attorney General Maura Healey, Congresswoman Katherine Clark, State Senators Michael Barrett, James Eldridge, and Karen Spilka, State Representatives David Linsky and Jay Kaufman, our very own Waltham Mayor Jeanette McCarthy, as well as Waltham City Councilors Kathleen McMenamin and George Darcy. And I want to give a very special warm welcome to a member of our audience, Frank Brandeis Gilbert, grandson of Justice Brandeis. Our centennial celebration of our namesake, Louis Brandeis, has been made possible by the dedication and inspiration of people too numerous to name. But I must give a special shout out to Brandeis class of 1957 alum, Jules Bernstein, and his wife, Linda Lipset, who first suggested the idea of the centennial celebration back in 2013. They got the ball rolling, and from the beginning, they've offered generous support, great wisdom, and practical guidance. I also want to thank Dan Terrace, Director of the International Center for Ethics, Justice, and Public Life here at Brandeis, who has skillfully led the initiative and organizing committee. His knowledge and organizational skills have been instrumental in making this centennial celebration a reality. 100 years ago on this day, January 28, 1916, President Woodrow Wilson announced the nomination of Boston attorney Louis D. Brandeis to the U.S. Supreme Court. The 59-year-old Brandeis wrote to his brother Alfred, quote, "I'm not exactly sure that I am to be congratulated, but I am convinced, all things considered, that I should accept." The public reaction to Wilson's announcement was swift and explosive. Former President William Howard Taft denounced the nomination, calling Brandeis, quote, "a muckraker, an emotionalist for his own purposes, a man of infinite cunning, of great tenacity of purpose, and in my judgment, of much power for evil," unquote. The New York Times complained that Brandeis, quote, "is essentially a contender, a striver after change and reforms," unquote. Yes, Brandeis was rather tenacious, and he certainly was striving to reform society. As a young lawyer, he and Samuel Warren wrote in 1890 an extremely influential essay in the Harvard Law Review that defined the right to privacy for the modern age in response to what they called the all too enterprising press and new technologies that could reproduce scenes or sounds. Later, when taking legal action to limit the number of hours that women were forced to work in certain industries, he invented a new form of argument, relying on data and evidence, not just legal theory. And the Brandeis Brief was born and became a staple of American law. When the growing power of mammoth financial institutions threatened to overwhelm the interests of small investors, he argued eloquently for limits on the ways in which financiers could use other people's money. Brandeis became known as the People's Attorney for his growing practice of pro bono work in the public interest. He spoke explicitly about his commitment to social justice an idea that he and other prominent thinkers of the progressive era brought into the public lexicon. For more than 4 months, the battle over Brandeis's nomination made headlines across the country. Some opposition clearly had its roots in anti-Semitism. Brandeis was the first Jewish American to be nominated to the High Court. The Senate Judiciary Committee held weeks of hearings, but according to the tradition of the time, the nominee himself was not invited to speak on his own behalf. On June 1st, 1916, Brandeis was on the train from his office in Boston to his home in Dedham, Massachusetts, when the Senate finally voted 47-22 to confirm his appointment as an Associate Justice of the Supreme Court. As the story goes, when he arrived home, his wife Alice met him at the door with a new greeting. "Good evening, Mr. Justice Brandeis." Louis D. Brandeis served on the Supreme Court for 23 years, creating a legacy of brilliant and innovative jurisprudence. His dissent in Olmstead versus the United States, which argued for limiting the government's use of technology to spy on its own citizens, continues to influence legal doctrine today. And his famous concurring opinion in Whitney versus California made freedom of expression not just an active force in American life, but a constitutional principle as well. Brandeis was a champion for the dignity of all individuals, as well as a protector of active citizenship, so that all could learn and freely debate ideas. In naming our university after this great justice, we have a responsibility to live up to his legacy. To quote Albert Einstein, "Brandeis is a name that cannot be merely adopted. It is one that must be achieved." And this is something we strive to do every day here at Brandeis University. Today begins a semester-long celebration of the centennial, aptly called Louis D. Brandeis Then and Now. Over the coming semester, in a variety of formats and venues, we will explore here at Brandeis the ways in which Justice Brandeis's legacy continues to influence and shape American law and society. I can think of no greater tribute to all that Justice Brandeis and this, his namesake university, stand for than to inaugurate our celebration with Justice Ruth Bader Ginsburg. There are many striking parallels between Justice Brandeis and Justice Ginsburg. Justice Ginsburg has dedicated her career as a litigator, judge, and justice of the Supreme Court to advancing equality under the law. Like Brandeis, Ginsburg has used fact-based jurisprudence brilliantly to advance social change, and both have used their opinions and dissents to educate the public about the social conditions that affect people's lives. But there are also key differences. When she enrolled at Harvard Law School, Ruth Bader Ginsburg was asked to justify taking a seat that could have been held by a man. She was one of only 9 women in a class of over 500. After transferring to Columbia Law School, she graduated at the top of her class, but yet she was turned down for every job to which she applied. But as Justice Ginsburg has shown countless times, from becoming the first tenured woman on the faculty at Columbia Law School to being recognized as a powerful voice on the Court for Equality, she is a force of nature. Underestimate her at your peril. As attorney and justice, her accomplishments are too many to cover fully here, but some include extending the Constitution's equal protection guarantee to women, ending pregnancy discrimination in the workplace, assuring gender equality in Social Security benefits, and striking down discriminatory admissions practices. I think that deserves a round of applause. Like Brandeis before her, Justice Ginsburg has written passionate dissents that in essence say to the court and to the world, take a look at what's really going on in society and the life circumstances people face. That's what she did, for example, when she dissented from recent decisions striking down the heart of the Voting Rights Act and allowing health insurance coverage to exclude women's access to contraception. A fierce intellect, a tireless voice for equality and inclusion, Justice Ginsburg has also become something of a pop culture icon. Known as the notorious RBG, by her ever-expanding fan base, which is clearly here in this room, she continues to inspire the next generation of social change agents and visionaries. At Brandeis University, our motto is truth even unto its innermost parts. For this evening, I propose to temporarily revise our motto to, without Ruth, there is no truth. Ladies and gentlemen, please join me in welcoming the one and only Justice Ruth Bader Ginsburg.
Thank you. Thank you. Please be seated. I so much appreciate the very warm welcome you have extended to me. And I'm here to talk to you for a bit about lessons I learned from Louis D. Brandeis. In these remarks, I will try to convey his impact on me in my years as a lawyer and then as a judge. I will speak first and longest of the Brandeis brief famously filed in Muller against Oregon. The Supreme Court decided that case in 1908. The court upheld as constitutional a 1903 Oregon law that prohibited employment of women in industrial jobs for more than 10 hours per day. In briefs filed in the 1970s, I described the Muller decision as an obstacle to Supreme Court recognition of the equal citizenship stature of men and women as constitutional principle. But while the Muller decision was one I tried to undo, the method Brandeis used to prevail in that case is one I admired and copied. Let me explain why I applaud Brandeis's method, but not the decision he sought and gained. In 1903, Oregon adopted a law setting 10 hours as the maximum workday for women employed in any mechanical establishment, factory, or laundry. Promoters of that state law limiting hours for women workers included labor reformers who first proposed an 8-hour day for all workers. When that proposal failed to gain legislative support, the proponents settled for a measure limiting the hours blue-collar women could engage in paid labor. Their hope was that a law protecting women would serve as an opening wedge leading in time to protection for all workers. Portland laundry owner Kurt Muller insisted that laundress Emma Gotcher work for more than 10 hours on September 4th, 1905, and that date had significance. It was the day the state had designated Labor Day to encourage employers to give their workers a holiday. The timing and Emma Gotcher's membership in the Laundry Workers Union suggested that Muller and fellow members of the Laundry Owners Association aimed to create a test case. As it turned out, they did. Oregon prosecuted Muller for violating the state's law. After an unsuccessful defense in Oregon's courts, Muller asked the U.S. Supreme Court to take the case and declare the state's 1903 law unconstitutional. Muller had cause to be hopeful. In 1905, the Supreme Court had ruled 5-4 in Lochner against New York that New York had acted unconstitutionally when it enacted a law limiting the hours bakers could work to 10 per day, 60 per week. According to the court, the hours limitation interfered with the right of bakery owners and bakery workers to contract freely, a liberty the court lodged in the 14th Amendment's Due Process Clause, which reads, "No state shall deprive any person of life, liberty, or property without due process of law." I was reminded of Lochner reading some decisions of the court concerning workers, consumers, credit card holders who signed agreements saying, if you have a dispute with us, you can bring it only in arbitration, not in court, and you cannot use the class action device. You must sue for your individual claim, which might be $30, and that's it. And that has also been described as tied to liberty of contract, the credit card holder signing the form, the employee signing the form. Well, getting back to Muller, the National Consumers League, led by social reformer Florence Kelley, wanted to ensure that Oregon would have the best possible representation. Kelley's first choice was Brandeis, but the League, while Kelley was out of town, had set up an appointment for Kelley with the celebrated New York bar leader, Joseph Choate. To Kelley's great relief, Choate declined to take the case. He told Kelley he saw no reason why a big, husky Irish woman should not work more than 10 hours a day if she and her employer so desired. Kelley next went to Boston to enlist Brandeis. She was accompanied by Josephine Goldmark, who was Brandeis's sister-in-law, and Goldmark was Kelley's associate in the Consumers League. Brandeis was then age 51. He said yes to the League on one condition. He wanted to be Oregon's counsel, not relegated to a friend of the court role, and he wanted to argue the case orally on the state's behalf. Kelley and Goldmark made that happen. Brandeis then superintended the preparation of a brief unlike any the court had seen up to that time. It was to be loaded with facts and spare on legal argument. Josephine Goldmark, aided by her sister Pauline and several volunteer researchers, scoured the Columbia University and New York public libraries in search of materials of the kind Brandeis wanted. Facts and figures on dangers to women's health, safety, and morals from working excessive hours, and on the societal benefits shortened hours could yield. Data was extracted from reports of factory inspectors, physicians, trade unions, economists, and social workers. Within a month, Goldmark's team compiled information that filled 98 pages of the 113-page brief filed by Brandeis. To show that Oregon was no outlier, that it did nothing radical, Brandeis first set out the statutes of the 20 states that had restricted women's on-the-job hours. And he also listed similar hours laws in force in Europe. His basic contention, the due process right to contract for another's labor, is subject to reasonable restraints to protect health, safety, morals, and the general welfare. To convince the court, Brandeis had to distinguish Lochner against New York. Bakers, the court had commented in Lochner, a job category overwhelmingly male, were in no sense wards of the state. Women, Brandeis urged, were more susceptible than men to the maladies of industrialization, and their unique vulnerabilities warranted the state's sheltering arm. The brief's pattern: after a line or two of introduction, Brandeis quoted long passages from the sources Goldmark and her associates had supplied. Now, some of those sources would hardly pass go today. For example, Brandeis quoted a medical expert who reported, "In the blood of women, so also in their muscles, there is more water than in those of men." Less imaginary, Brandeis emphasized the effect of overworking women on the general welfare. Infant mortality rises, he told the court, while the children of married working women who survive are injured by the inevitable neglect. The overwork of future mothers, he added, directly attacks the welfare of the nation. On the benefit side, Brandeis stressed that shorter hours allowed women to attend to their family and household responsibilities. According to a source he quoted, free time for a woman is not resting time as it is for a man. For the working girl, on her return from the factory, there is a variety of work waiting. She has her room to keep clean, her laundry work to do, clothes to repair and clean, and besides this, she should be learning to keep house if her future household is not to be a disorderly failure. To allay the concern that shorter hours were bad for business, Brandeis excerpted studies of more contemporary resonance showing that maximum hours laws improved productivity. The brief's bottom line: decades of well-documented experience at home and abroad showed that Oregon's legislature had good reason to believe that public health, safety, and welfare would be advanced by limiting women's paid work to 10 hours per day. Now, counsel for laundry owner Muller scarcely anticipated the mountain of social and economic material the state, through Brandeis, would present. But Muller's brief made a point equal rights advocates of my day embraced. Most of the disadvantages facing women in the labor market derive from society, not biology, Muller argued. Social custom, not inferior ability, he urged, narrow the field of their endeavor. Ostensibly, the brief continued, Oregon's law was framed in women's interests, but it was intended, Muller suggested, perhaps to limit and restrict women's employment in order to give a boost to women's competitors for blue-collar jobs among men. The Supreme Court heard argument in the Mueller case only 5 days after receiving the voluminous Brandeis brief. Such a short time between briefing and argument would not occur today. Less than 6 weeks after argument, and these were days with no PCs, 6 weeks after argument, the Supreme Court announced its unanimous decision upholding Oregon's law. Justice Brewer, who was a member of the 5-4 majority that invalidated New York's maximum hours legislation in Lochner, authored the court's relatively short opinion. Brewer took the unusual step of acknowledging the copious collection of statutes and reports, domestic and foreign, in Brandeis's brief. But then he put his own spin on the materials. The justice found in those materials confirmation of eternal, decidedly unscientific truths about men and women. According to Brewer, history shows that woman has always been dependent upon man. In the struggle for subsistence, he wrote, she is not an equal competitor with her brother. She is so constituted that she will rest upon and look to him for protection. Brewer then switched images from man as protector to man as predator. Woman's physical structure and a proper discharge of her maternal functions, he wrote, justify legislation to protect her from the greed as well as the passion of men. Did the justices rule in Oregon's favor in the Mueller case because they were impressed by the extraordinary quality of the Brandeis brief? Or did they hold for Oregon because the Brandeis brief shored up their own preconceptions about the relationship between the sexes, the physical superiority of men, women's inherent vulnerability, and society's interest in the well-being of women as actual or potential mothers? Would Brandeis's technique work when social and economic data was inconsistent with traditional views about the way women are, and was used to challenge, not to defend, sex-based classifications in the law? As a law student in the late 1950s, I learned in my constitutional law class that Mueller marked a first break from the court's refusal to uphold social and economic legislation attacked as invading the liberty to contract once thought to be secured by the 5th and 14th Amendments due process clauses. Mueller was a decision to applaud, New Deal-oriented professors taught us. Just over a decade later, briefing gender discrimination cases in or headed for the Supreme Court, I looked at Mueller differently. The decision, I appreciated, was responsive to turn of the 20th century conditions when women labored long into the night in sweatshop operations. But, I observed in 1970s briefs, as the workday for industrial workers, male and female, shortened from 12 hours to 8 and the work week from 6 days to 5, laws limiting only women's work were in many instances protecting women from better paying jobs and opportunities for promotion. However well-intentioned, such laws could have a perverse effect. They could, and all too often did, operate to protect men's jobs from women's competition. The very point that Kurt Mueller made in days when it carried less credibility, in days when unregulated work weeks with no overtime pay could run 72 hours or even more. In briefs and commentary, I included Muller in a trilogy of cases that bore particularly close examination for the support they appeared to give to perpetuation of the treatment of women as less than full persons within the meaning of the Constitution. The other decisions in the trilogy were Gossett against Cleary, which in 1948 upheld a Michigan statute prohibiting women from working as bartenders, citing moral concerns, and Hoyt against Florida, which in 1961 upheld a state statute excluding women from the obligation to serve on juries because of their place at the center of home and family life. While equal rights advocates attacked the substance of the Muller decision, they were hugely inspired by Brandeis's method. The aim of the Brandeis brief was to educate the judiciary about the real world in which the laws under inspection operated. That same aim motivated brief writers in the Turning Point gender discrimination cases, Reed v. Reed, decided in 1971, and Frontiero v. Richardson, decided in 1973. Reed was the first case ever in which the U.S. Supreme Court disapproved a classification based on gender. The Idaho statute involved in Reed was once typical. It read, as between persons equally entitled to administer a decedent's estate, males must be preferred to females. Two federal statutes, also typical of the time, were involved in Frontiero. Both laws granted fringe benefits to married male military officers, but withheld those benefits from married female officers. The Brandeis brief presented economic and social realities in justification of protective labor legislation challenged as unconstitutional. In Reed, Frontiero, and later 1970s gender discrimination cases, Brandeis-style briefs explained that as the economy developed and society evolved, laws premised on women's subordinate status violated the Constitution's guarantee of the equal protection of the laws to all persons. The social and economic facts urged in Reed and Frontiero aimed to open jurists' eyes. Copying Brandeis's method was useful to that end. Laws once thought to operate benignly in women's favor, keeping them off juries, relegating them to women's work in the military, for example. In time, those laws came to be seen as measures impeding women's opportunity to participate in and contribute to society based on their individual talents and capacities. Another lesson learned from Brandeis. Much legislation into the 1970s was based on the premise that men were breadwinners, women, men's dependents. So, for example, when Stephen Wiesenfeld's wage-earning wife died in childbirth, he sought the Social Security benefits that would enable him to care personally for his infant son. They were called child-in-care benefits, available when a wage earner dies with a spouse and young child surviving. If the deceased wage earner was a man, there were monthly benefits for widow and child. But if the wage earner was a woman, as Paula Wiesenfeld was, there were no benefits for the widower. On behalf of Stephen Wiesenfeld, I asked the court essentially to write into the statute the fathers Congress had left out, to convert the mother's benefit into a parent's benefit. Can't be done, some of my academic colleagues told me. The court might nullify the mother's benefit, leaving it to Congress to start over from scratch, but it would be out of bounds for the court, lacking the power of the purse to order payments to widowed fathers. That's just what the government initially argued. In the district court, the government urged dismissal of Stephen Weisenfeld's complaint. It is clear the government maintained that the plaintiff does not complain about what Congress enacted, a mother's benefit. He complains about what Congress did not enact, a father's benefit. He has therefore chosen the wrong forum for the relief he seeks. He should take his complaint to Congress. That argument, had it been accepted, would have immunized from judicial review statutes that confer benefits unevenly on women only or men only. The legislature would have the power, unchecked by the judiciary, to diminish the equal protection principle. Was my position radical? Precedent was slim, but what there was had heft. It started with Brandeis in a case decided in 1931 involving state taxation, Iowa Des Moines National Bank against Bennett. Complainants in that case were a national and a state bank. Their complaint, Iowa officials taxed them at a rate higher than the rate challenged corporations in competition with them. Brandeis wrote for a unanimous court that the banks were entitled to a refund of the excess taxes exacted from them. He explained, the petitioners' rights were violated when taxes at a lower rate were collected from their competitors. It may be assumed that all ground for a claim for refund would have fallen if the state, promptly upon discovery of the discrimination, had removed it by collecting the additional taxes from the favored competitors. By such collection, the petitioner's grievances would have been redressed. The right invoked is that to equal treatment, and such treatment will be attained if either their competitors' taxes are increased or their own reduced. But it is clear that a taxpayer who has been subjected to discriminatory taxation through the favoring of others in violation of federal law cannot be required himself to assume the burden of seeking an increase of the taxes which others should have paid, nor may he be remitted to the necessity of awaiting such action by the state officials on their own initiative. Typically clear expression from Brandeis's pen. In a 1970 decision, Welch against the United States, Justice Holland followed and expanded upon Justice Brandeis's lead, explaining, where a statute is defective because of under-inclusion, there exist two remedial alternatives. A court may either declare it a nullity or may extend the coverage of the statute to include those who were aggrieved by the exclusion. Thanks in part to the Brandeis and Holland's opinions, the court saw the light. In Frontiero, it did not nullify benefits enjoyed by married male officers. Instead, it extended those benefits to married female officers. And in Weisenfeld, instead of nullifying benefits enjoyed by widowed mothers, it extended those same benefits to widowed fathers. In several later cases, the court followed the same path. In connection with the soon-to-be-published book titled Louis D. Brandeis, An American Prophet, author and head of the Constitutional Center in Philadelphia, Jeffrey Rosen, asked me about Brandeis's influence on me. I spoke, of course, about the Brandeis brief and the brief written in the Turning Point Reed v. Reed case. Self-consciously Brandeisian, the Reed brief attempted to document through citation to economic, social, and historical sources the artificial barriers imposed on women by law and custom, suppressing their aspirations and opportunities to achieve. I also spoke of Brandeis as justice, his craftsmanship, sense of collegiality, ability to combine a dedication to judicial restraint with the readiness to defend civil rights and liberties when the values our Constitution advances required it. Brandeis worked hard on his opinions, I responded to Jeff, as evidenced by the number of drafts he composed. He cared not only about reaching the right bottom line judgment, he cared very much about writing opinions that would enlighten other people. I also admired Brandeis, I told Jeff, for his determination to dissent or concur separately only when he felt the public really needed to hear his separate views. Alexander Bickel published a book in 1957 compiling Brandeis's unpublished opinions. Not many jurists, I observed, would go through the hard labor of writing an opinion, then step back and ask, is this opinion really needed? His dissents were all the more influential because of his self-imposed restraint. A further admirable quality, Brandeis's views could change when information and experience showed his initial judgment was not right. In the 1880s, he opposed extending suffrage to women. Men were doing well enough in conducting the nation's political affairs, he thought, and they had obligations women escape. Military service, for example. He might have added jury duty. By the 1910s, however, Brandeis had become an ardent supporter of votes for women. Perhaps it was the influence of his wife and a daughter who took a year off between college and law school to campaign for women's suffrage. Perhaps it was the able women he encountered among his social reformer friends, Jane Addams, Florence Kelley, his sister-in-law Josephine Goldmark, and a number of others. Voting was a citizen's right, he recognized, but it was also a citizen's obligation. No class or section of the community is so wise or just, he came to see, that it can safely be trusted to govern without the participation of other classes or sections. What of interpretive approach, Jeff asked. Brandeis's purposive interpretation of statutes and our fundamental instrument of government place him high among jurists who interpret legal texts sensibly, I answered. He was certainly not an admirer of what was once called legal classicism, which seems to me similar to today's originalism. As an example, I mentioned the June 2015 healthcare decision. Brandeis, I have no doubt, would have agreed with the majority's decision to salvage, not destroy, the Affordable Care Act. He would not say, as the dissenters did, that because the act used the words exchange established by the state, the text must be interpreted in a way that would undermine the entire act. One could not attribute to a responsible member of Congress an outcome so bizarre. I ventured, too, that Brandeis would have deplored the court's 2010 decision in Citizens United against FEC. That, as you know, struck down restrictions on corporate campaign spending. Brandeis had pointed out in 1933 in his dissent in Louis K. Leggett Company against Lee that legislatures throughout the 19th and early 20th century had imposed a host of restrictions designed to ensure that the corporate form would not threaten equality of opportunity and the autonomy of individuals. When Brandeis retired in 1939, after 23 years of distinguished service on the Supreme Court bench. He had written 448 opinions of the court and published 10 concurring opinions and 64 dissenting opinions. It is fitting, I hope you agree, to conclude these remarks with the appraisal of his work by his colleagues expressed in their farewell letter. Your long practical experience and intimate knowledge of affairs, the wide range of your researches, and your grasp of the most difficult problems, together with your power of analysis and your thoroughness in exposition, have made your judicial career one of extraordinary distinction and far-reaching influence. That influence, I can attest, continues to this day. Thank you.
Justice Ginsburg, thank you for your inspiring remarks. What a terrific way to start our examination of Louis Brandeis then and now. I'm happy to note that Justice Ginsburg will return to our stage and join our panel a little bit later in our discussion. Now it's my great pleasure to welcome back to campus former President Frederick M. Lawrence. If he looks a little relaxed, it's because he's currently on sabbatical at Yale Law School. While president of Brandeis, Fred often talked with students about Justice Brandeis's inspiring legacy, especially with respect to the inherent right of free expression and the role of the citizen in a democracy. As Brandeisians, we debate, we discuss, and we practice the art of dissension all the time. So it's fitting that Fred Lawrence, a noted scholar, teacher, and attorney dedicated to understanding and advancing freedom of expression, is our moderator for this evening's panel discussion entitled Louis Brandeis, the Supreme Court and American Democracy. Please join me in welcoming Fred Lawrence.
Thank you, Lisa, and good evening to all. I hope that Justice Ginsburg backstage, where she's getting some well-deserved time to sit down, can hear me if I share some thoughts in response to a question that I always asked during my years as president of Brandeis, which was, what would Louis say? Now, I'm quite sure that were Justice Brandeis with us now, he would be known as the notorious LDB. And so it's fair to ask, what would the notorious LDB say about the notorious RBG? And I think he would say that they have many things in common. They are two who have transformed the practice of law through their practice careers. They are two who, through their practice and time on the bench, saw and have seen law as an engine of social change and a core piece of American democracy. Louis Brandeis, of course, was the first Jewish American to serve in the United States Supreme Court, nominated 100 years ago today in 1916. Justice Ginsburg, the first Jewish American woman on the court, nominated and confirmed in 1993, I would note that if my arithmetic is right, she will pass Justice Brandeis's record for service on the court on the 20th of April this spring. That would make her, for those who keep track of such things, and I bet there are a few of us on this panel who do, that would make her 35th on the list of the court in years of service. But if we were to invoke upon the notorious RBG the classic lawyer's wish and blessing, which in Latin is ad mea esrim, that she should live to 120, then she will smash even William O. Douglas's record of 36 years of service on the United States Supreme Court. So what would the notorious LDB say about the notorious RBG? I think he would take enormous pride that the university named for him, that bears his name, conferred upon her an honorary doctorate some years ago, and so she is, in fact, an alumna of Brandeis University. So Justice Brandeis might say to Justice Ginsburg, "Welcome home." Indeed, if I may be permitted a moment of personal privilege, he might say that to both of us tonight. Now, our panel tonight is an extraordinarily distinguished group who will help us start this semester-long inquiry on a topic tonight of Louis Brandeis, then and now, and particularly his contribution to law and democracy, the pieces of Brandeis's life and work that continue to resonate still. I will introduce them to you briefly in the order in which I will ask them to respond to the first question, which will be one example, and there are so many, one example and briefly, and one could be so long, of how Brandeis's work still resonates in the development of American law, American democracy. Chief Justice Ralph Gants, who's the chief, yeah, that's an applause line, go ahead. Chief Justice Gants, who's the Chief Justice of the Massachusetts Supreme Judicial Court, served on the Superior Court for over a decade when Governor Deval Patrick appointed him to the SJC in 2009 and then elevated him to Chief Justice in 2014. He, before that, was an Assistant U.S. Attorney here in the District of Massachusetts, and you're going to see that's a repeating theme, Assistant U.S. Attorneys here on this panel. Chief Justice Gants has taught both civil and criminal procedure advocacy at a number of the area law schools, and to bring it back home, the last time he and I were in this building together, he brought greetings on behalf of the Commonwealth at my inauguration. So Chief Justice Gants, you honor us by your presence tonight. Thank you. Judge Mark Wolf, who is a former Chief Judge of the District of Massachusetts Court. As a former president, I can say being a Chief Judge is a great thing. Being a former Chief Judge, now that's a really great thing. Judge Wolf was appointed to the District of Massachusetts bench as the United States District Court Judge in 1985, which I do believe makes you the senior judge in this whole room tonight, including Justice Ginsburg. Brandeis had you by a few years, but 1985 goes back. His cases involve organized crime and FBI corruption, among many, many others. Judge Wolf was an AUSA here in the District of Massachusetts and served with great distinction in the Department of Justice. He has, since taking senior status, adopted an extraordinarily important international focus in his work and is a very good personal friend of this university and his connection with it. Judge Wolf. Dr. Philippa Strum, we welcome home as a distinguished member of the great class of 1959. Philippa is a senior scholar at the Woodrow Wilson International Center for Scholars, Professor Emerita, the City University of New York, distinguished author on a number of topics in the law, but for our purposes tonight, I'll mention two very important books, Louis D. Brandeis, Justice for the People, and Brandeis, Beyond Progressivism. Dr. Strum, welcome home. And last but certainly not least, Jeff Toobin, also an AUSA, former AUSA from the Eastern District of New York. Now, those of us who served in the Southern District of New York know about the rivalry between our two offices, and the main reason that rivalry was so intense is no one else in the country could possibly take it seriously besides us. Jeff is the senior legal analyst for CNN, staff writer for The New Yorker on law, and author of multiple books on law, including The Nine, Inside the Secret World of the Supreme Court. Many academics and teachers here tonight who have taught hundreds or thousands, but in your work at CNN and The New Yorker, I think it is fair to say, Professor Toobin, you have taught millions. You honor us by your presence tonight. So, ladies and gentlemen, let's get started. I'm going to ask Chief Justice Gans to kick it off with an example, briefly, of some aspect of Brandeis's contribution to law and democracy as a practicing lawyer or as a justice that still resonates deeply with us today. Mr. Chief Justice.
I'm going to discuss Brandeis as attorney, which he was for the first 59 years of his life. As an attorney, Louis Brandeis reshaped the vision of what it meant to be a lawyer with a social conscience, and he challenged the predominant vision of the lawyer in his day and frankly in our day. He was not the first person to invent the idea that lawyers do free legal work, what we call pro bono work, but I think it's fair to say that he was an uber pro bono attorney, and by Uber I do not mean ride sharing. He described his commitment to pro bono in a way that I find to be quite terrific, so let me give you his words. He wrote, "Some men buy diamonds or rare works of art. Others delight in automobiles and yachts. My luxury is to invest my surplus effort beyond that required for the proper support of my family to the pleasure of taking up a problem and solving or helping to solve it for the people without receiving any compensation. I have only one life and it is short enough. Why waste it on things I don't want most? I don't want money or property most. I want to be free." By 1910, when Brandeis was 54 years old, he devoted virtually all of his time to pro bono work, doing mostly what we would now call impact litigation or impact projects. He wrote the Brandeis brief in Mueller that was described earlier by Justice Ginsburg, and he wrote that for free. He fought what was then called Boston Elevated's attempt to obtain a monopoly with regard to the streetcars in Boston, later to the subway in Boston. He battled utilities over rate setting. He challenged the insurance companies by helping to create savings bank life insurance, to create low-cost insurance for working families. Why did he do this? He did it, I think, for two reasons. First, he took great joy in solving problems. He would often say when he was retained by one side, he says, "You know, why don't you make me the counsel to the situation? Why don't you be," and often he would serve what we would now call to be a mediator. He would essentially address both sides. He would attempt to strike a balance between competing claims, and he would work out an equitable solution. We need more lawyers who will be a counsel to the situation. But he also saw an enormous increase in the inequality of income in the early 20th century. And he recognized that if the excesses of wealth were not restrained and regulated by law, capitalism itself would be destroyed by populist anger. Sound familiar? In 1905, in a speech he gave at Harvard at the Phillips Brooks House, he said, "Our country is, after all, not a country of dollars, but of ballots. The immense corporate wealth will necessarily develop a hostility from which much trouble will come to us unless the excesses of capital are curbed through the respect for law, as the excesses of democracy were curbed 75 years ago," referring to Jacksonian democracy. "There will come a revolt of the people against the capitalists unless the aspirations of the people are given some adequate legal expression." He noted that corporations had lawyers, but the public did not. And when they did, those lawyers were not very good. He said, "We hear much of the corporation lawyer and far too little of the people's lawyer," so he became the people's lawyer.
Judge Wolf, an example.
I would say an example of one of Justice Brandeis's greatest contributions to democracy was his fierce dedication to combating corruption and giving integrity to the rule of law. As we discussed, as we planned the panel, I've long admired Justice Brandeis for his capacity for growth. And it wasn't growth or change that came from going to the library or reading in the serenity of his chambers, but from interacting with a very wide range of people. One vivid example of that is Justice Louis Brandeis had no particular Jewish identity before about 1910. He didn't just live in Dedham, he was probably the only Jewish member of the Dedham Polo Club. And he was called upon, he was a great mediator, counsel for the situation. He was called upon to mediate a garment workers' strike in New York, which had Jewish people as the employers, and Jewish people fitting a very different profile, probably, perhaps literally my grandmother, doing the work. And he was impressed by both sides of this dispute, and he became proudly and publicly a Jew. And that's in 1910. In 1914, he became the president, the head of the American Zionist Organization, and was vying with Chaim Weizmann to be leading the International Zionist Organization. But his interest in Palestine was not primarily as a haven for endangered Jewish people, but as a laboratory for democracy, because he envisioned it as a place where perhaps the Periclean ideals could be achieved. A very comparable evolution is seen with regard to him as a public advocate, an opponent of corruption. Brandeis is reportedly had the highest grades of any student at the Harvard Law School in the 19th century. And when he graduated, he formed a firm with a Boston Brahmin, Sam Warren, and represented the widest range of powerful interests. But one of them was the Filene's of blessed memory, the department store on Washington Street. And I'll conflate things a bit. Hopefully Philippa won't give me too low a grade, but there were a series of matters that Chief Justice Gantz alluded to. Filene's and the other merchants downtown learned of essentially a covert effort by the Boston Elevated Company and others to get a very long time monopoly to build a subway, first under Boston Common and then under Washington Street. And it would guarantee them the grand sum, a guarantee that the fare would never be less than 5 cents for any trip. And this was of great concern to Filene's and his colleagues because 5 cents was a lot of money then. And they were afraid that people wouldn't come downtown and shop. So they put their formidable, brilliant lawyer, Louis Brandeis, on the case. And he found a variety of corruption, including legislators who were using the transit authority for patronage and wouldn't oppose it because it provided jobs, perhaps an enduring tradition in Massachusetts. So the last moment came for the legislation. The lawyer from the Elevated came in to the legislature and, not giving any advance notice of his argument, said, if we don't get those terms, our company will fail. We're going to be impoverished. But Brandeis was, as others have said, the master of facts. And he knew that the Elevated company had increased its dividend the year before, was actually making a lot of money. And he was able to recite those facts quickly, defeat the legislation, and keep what really should be a public resource, a public service in the public. This led him to be a passionate opponent of municipal corruption. He led and formed many great good government organizations, one called the Good Government Association of Boston. And in 1903, before he was iconic, a young man named James Michael Curley was convicted of fraud and on his way to prison, and he was a candidate for alderman in the city of Boston. So Brandeis gave a speech, and he said, "Think of the effrontery of this man, James M. Curley, standing before the people of Boston as the nominee of a great political party, within 3 months of the day when he was convicted by a jury of the crime of conspiracy to defraud the government of the United States. The waste and theft of public monies which result from having such men in office is bad enough, but 100 times worse is the demoralization of our people which results. Nothing breeds faster than corruption. Every criminal in the public service is a plague spot, spreading contagion on every hand. Think what a heritage we leave to your children if corruption is allowed to stock unstayed. The ships which carry the products of our rich country to other lands come back freighted with thousands of men and women and children who, fleeing from the oppression or the hopelessness of their old homes, see this as a land of liberty and opportunity. Shall we permit these, our fellow citizens, perhaps our future leaders, to be taught that in Boston, liberty means license to loot the public treasury, and that in Boston, opportunity means a chance for graft? The poet William Blake said that honest indignation is the voice of God, and I think in that quote you see why Brandeis was regarded as a Hebrew Bible prophet, often called Isaiah. In 1910, he took this fight against corruption to Washington. William Howard Taft was the president. Richard Ballinger was the Secretary of the Interior. Ballinger quite covertly transferred 5,000 acres of timber, very valuable timber and oil land, to the Guggenheim Morgan interests. And the great conservationist under Teddy Roosevelt, Gifford Pinchot, exposed this. Collier's Magazine publicized it, and it created a great controversy as to whether Ballinger had acted corruptly. And President Taft said, I've received a report from my Attorney General, George Wickersham, and I find that Mr. Ballinger has acted quite properly. Well, there were congressional investigations. Collier's hired Brandeis to represent it because they feared libel suits. And Brandeis, by meticulously putting together facts in the public record, demonstrated that the Wickersham 54-page memo was backdated. Taft didn't have it when he cleared Ballinger. Taft had lied, Ballinger had lied, Wickersham had lied. So this makes it not surprising that Taft and Wickersham were these virulent opponents of Brandeis when he was nominated. Also among his opponents were the Brahmins and powerful interests in Boston who felt that Brandeis, originally their lawyer, had not just beaten them, but betrayed them. And coming to Brandeis's defense was his protege, young Harvard Law School professor, Felix Frankfurter, who wrote in the New Republic in response to these really passionate allegations that Brandeis was unethical and lacked judicial temperament. Frankfurter wrote, "It is said of Mr. Brandeis that he is often not amiable in a fight. There is truth in that statement. The law has not been a game to him. The issues he has dealt with have been great moral questions. He has often fought with great severity. He has rarely lost. His great fights have been undertaken in the public interest." And that remains a much needed and inspiring model today. Brandeis often said we must struggle in each generation to truly possess what we've inherited, and that is why I say that Justice Brandeis's ferocious dedication to combating corruption is one of his greatest contributions to democracy.
It's extraordinary that both of you have been talking about Justice Brandeis before his appointment to the court, so by definition all of these stories are at least a century old, and yet they have a freshness and currency that really speaks to our situation today. Philippa?
Thank you. Let me just tell you, those of you who saw me shuffling papers while Justice Ginsburg was speaking, I wasn't being rude. I have a hearing disability, and she knows that, and so she very graciously brought a copy of her remarks for me to read, knowing that I would not be able to hear much of what she said. Let me pick up on the notion of Brandeis as a Democrat. one of his colleagues called Brandeis an implacable Democrat. And related to that was one of the lines that Brandeis liked best of all of the poetry he read. It's a line from the English poet Matthew Arnold, and it is, "Life is not a having and a getting, but a being and a becoming." And that ties in with what you were saying about his ability to change. But what he wanted was a society where every person could concentrate on a being and a becoming. In other words, to Brandeis, democracy was not an end. Democracy was a process. And the process was meant to do what he thought was incredibly important, create the conditions by which human beings had a chance for self-fulfillment, had a chance to bring out the best in themselves, had a chance to work at something that was meaningful to them. Well, in order to do that, societal conditions had to permit them to explore their capabilities. But societal conditions changed. And therefore, as Justice Ginsburg has said, and as the speakers have emphasized, it was necessary for the law in a democracy to change as the societal conditions changed and as the people had to adapt themselves to new societal conditions. But what the people wanted out of every new societal condition was something that the lawmakers had to ascertain. More than that, however, the people themselves had to decide what it was that they wanted. What public policies did they want? What kind of laws did they want? Well, the only way for them to know that, according to Justice Brandeis, was to constantly educate themselves. And by education, he didn't mean going to school. He meant reading constantly. He meant talking to other people to get their ideas. To him, the most important thing about the right to speech was not actually the right to speak, but the right to hear. And he felt strongly that if every citizen did not have the opportunity to hear all of the ideas out there in society, then that citizen would not be able to function as he or she should have been able to as a member of a democratic society. So active citizen participation in the process of democracy was absolutely crucial to Brandeis. He emphasized speech. He wrote to this day, I think you will agree, the greatest statement about the relationship between speech and democracy. But the reason for it was to let you, the citizen, we, the citizens, hear all going ideas so as to participate. The worst thing for him in a democracy would have been stifling speech. And I think he must have appreciated this kind of campus where speech presumably is as free as it possibly can be. So that's really what I think about when I think of Brandeis as a Democrat.
Jeff, I purposely asked you to bat cleanup on the thought that we'd have a number of ideas on the table that you could react to and raise some of your own.
Okay, well, here's a thought about Justice Brandeis that has always been resonant to me. The dates of his life. He lived from the Civil War to World War II, a little more than 80 years, which is one of the most extraordinary periods of change in the history of any country anywhere. You know, if you were 80 years old at the time of the Civil War, the world you grew up in was not hugely different from the world that you lived in at that point. And if you were born during World War II and lived to be 80, you know, you had cars and trains and planes. But if you were born in the Civil War at a time when everyone traveled by horse and buggy, and you died when the Manhattan Project was underway, building an atom bomb, you saw the most dramatic change, certainly in history of this country and maybe anywhere. And I think Justice Brandeis's career as both a lawyer and as judge is the story of his response to the Industrial Revolution and what was going on in the United States. And I think he was at his best when he was looking forward to the world that was becoming, and he was less than his best when he was looking back and trying to recreate a world that was vanished. And in terms of looking forward, I mean, he is associated with the idea of factual inquiry to address the problems that exist in the world. The famous Brandeis Brief, which everyone has talked about, is about how the government can address people's problems in a practical way. It is a departure from the formalistic rules that govern law through much of the previous time. I mentioned also, you know, the Supreme Court. I'm glad Justice Ginsburg isn't here when I say this, but you know, the Supreme Court during most of Justice Brandeis's life was a miserable, awful institution that
She
got
is
basically,
backstage, by the
Well,
way. She
that's
can hear
fine.
all of this.
I knew
so.
she was listening, and I, you know, but it was a horrible institution that got almost everything wrong. You know, from the death of Chief Justice Marshall in, I think, 1829, until the early years of the New Deal, the Supreme Court was an absolutely terrible institution dedicated to the worst of American life, whether it was the Dred Scott decision in 1857, or Plessy versus Ferguson in 1896, or Lochner in 1905. I mean, everything they did was wrong. So the idea that you could look to the courts as a source of salvation was not something that a progressive like Louis Brandeis could do. So he was someone who believed in legislation, and one reason he was so associated with the idea of judicial restraint as a judge was he knew that the courts got everything wrong. So it was better to let the legislative process proceed. Now, that was the forward-looking Justice Brandeis. The backward-looking Justice Brandeis was the one who had a almost pathological fear of bigness. He was someone who felt that big companies, big governments, was always wrong, and he was someone who believed a great deal in states' rights. And I think as the country became more industrialized, he failed to recognize that you needed bigger institutions to control to control what was going on in the company. And I think, you know, the architects of the New Deal recognized that more than he did. The other subject where I think he did more looking backwards than he might have is particularly in his famous, but more famous than read article, The Right to Privacy, which he co-wrote in the Harvard Law Review, which is basically a diatribe against the press for bothering rich people. Now, I don't have a great deal of sympathy for that position. I mean, the idea that you know, the right to be left alone from the press is one of the salient rights guaranteed by the Constitution. I actually don't think that's the case. And I think, you know, the famous dissents that he and Holmes wrote after World War I established, you know, this libertarian ideal of the First Amendment, that the marketplace of ideas, which is actually, I think, Holmes's phrase, not Brandeis's phrase, but certainly it's consistent with Brandeis's view that the best thing the government could do was let all speech flourish, and that would lead to the best results, because people would make a reasoned judgment from all the voices they heard, and then make the right decisions for society. And it wouldn't matter who had the loudest voice, it would only be the best voices that would triumph. He didn't anticipate the Trump campaign. And the point, and so the metaphor, the libertarian ideal that he has established and expressed so beautifully, I think, you know, if I can disagree with Justice Ginsburg a little, I'm not sure it didn't lead to Citizens United, because if you believe that the government should withdraw from the field of any sort of speech regulation, then you do let the Koch brothers spend whatever they want for you know, the political goals that they shared. So that's what I think.
Well, it seems to me that having invoked our keynote speaker a number of times, that we should invite her back to join us on the stage for a few last questions before we break for the evening. And actually, I'm going to pick up just where Jeff left off, and I think there's a tendency to, if someone's a hero, like a Louis Brandeis, who I do think of as a personal hero, to then therefore read him into whatever position we'd want to have in the present. But I think at the risk of playing the almost impossible game, the what would Louis Brandeis do 100 years later, but that's sort of what we're doing in this then and now setting, is to refract his views through into the present, and particularly with respect to technology and how technology has changed so many different ways of how we communicate and how amalgamations of wealth are possible in an entirely different way, and ask if any of you, each of you, has some thoughts as to whether or not he remains the libertarian in a world that has the potential for concentrations of wealth that even he could not have imagined having lived through the Gilded Age, or does he understand that bigness, private bigness, requires public bigness to deal with it? Now that's a conflict that in some ways he leaves unresolved in his life, but we don't get to leave it unresolved 100 years later. So what are thoughts on how Louis Brandeis might wrestle with that? And I'll give you either the chance to do it Louis Brandeis the thinker, Louis Brandeis the lawyer, or Louis Brandeis the justice, where, just to complete the thought, as Jeff said, he did actually practice the passive virtues in a way that we tend to forget about. I think Justice Ginsburg's apt reflection of the sheer number of opinions that he wrote but didn't publish, which is astounding. There are those who think that there are opinions today that aren't written that are published. And that's a different problem. I'll let that sink in there for a second before we move on. So the question is, Brandeis looking at the world today and seeing great collections of private power, does he remain a libertarian who thinks the government ought not to limit that? Or does he see that public bigness is needed to combat private bigness? And this time I'm not going to...
But I think I have to say in answer to Jeff, he was quite explicit about the need to control corporations. So that's why I have no doubt that he would be where...
But it's not corporations that are spending all that money, it's individuals. Citizens United, I think, is often misconstrued, where it's, given all the... But because people think it's given corporations a license to spend lots of money. The corporations have spent almost no money since Citizens United. The problem with Citizens United, at least the way it's been interpreted by the courts, is that it's given individuals an unlimited ability to spend whatever they want on political expenditures, and that's the big problem.
So the question still stands, but private bigness, as I've described it, not just meaning corporate private bigness, right, but concentrations of wealth. Judge Wolf.
I go back to my observation that one of the most admirable characteristics of Louis D. Brandeis was his capacity for growth based on learning and experience. This is another program, but I think the problem with Felix Frankfurter was he was trying to be Louis Brandeis as if it was a snapshot, not a process, a moving picture. Something like Citizens United implicates three things that Brandeis felt strongly about: speech, but also judicial restraint, deference to legislation, and the effective operation of democracy. And I think that Brandeis, were he in this millennium to address the issues in Citizens United, would have evolved to the view that one, substantial deference was due to the Congress and the President to share a responsibility for constitutional interpretation, and two, democracy requires that everybody be able to effectively participate. And if something big, because he was a great opponent of bigness, was essentially drowning out other voices or overwhelming them, I think that judicial restraint and wanting to keep the political process relatively fair would trump what we look back on as his great commitment to, almost unqualified commitment, as you said, to free speech.
You know, it's always a little bit dangerous to ask what would Brandeis say about almost anything when you consider that this was a man who said you have to respond to the societal necessities of the moment. And obviously, Brandeis couldn't know about the societal necessities of this moment. I mean, I'm wrestling right now with the question of what would Brandeis, with his emphasis on speech, think about the problems presented by the internet, like cyberbullying and terrorist recruitment. And I can't say Brandeis would have said, because how could he possibly imagine those things? But I think Justice Ginsburg hit upon one of the few areas where we can say we're reasonably sure what Justice Brandeis would say. And that is the power of big corporations in the United States. The one thing that he fulminated against more almost than anything else was overly large businesses and the power that they would have, the evil that they would do to the political process. That was his concern. And what he would say is, if an entity, whether it's a governmental entity or an economic entity, is so big that the man at the top, because in those days it was the man, if the man at the top doesn't know what everybody is doing, then it is not too big to fail. No, we should not have anything that's too big to fail. And I think he would say this is exactly the problem with huge corporations, that they can participate in the political process in a way that negates, as you suggested, the voice of the individual. So I think that we can say with Citizens United, we don't really know whether he would be rolling in his grave today, but I think he would be extraordinarily distressed about the limitations on individual voices in the political process, as exemplified by Citizens United.
Flip made an essential point. The times are different, but the one thing that we do know, and I gave a couple of examples, is that Brandeis was able to change. He was able to see that his initial thinking was wrong. And that was true of Zionism, and it was true of the suffrage movement. He had just gone totally around on both of those issues. So I think we have no way of projecting what he would do if he was here, but we do know that he was somebody who listened and learned throughout his life.
Ralph?
I speak to Justice Brandeis every day because his portrait hangs behind my desk. I do most of the talking. But I am...
Does he talk back?
Ralph, I used to tell the
On the
students
advice
that
of counsel, I will not answer that.
I used to tell the students that I talk to the statue of Justice Brandeis on campus every day. That should not make them nervous. When I tell you he's talking back to me, that should make you very nervous.
But there are two things that I am confident of. One, I am very confident that when questions would emerge as to the constitutionality of the search of a cell phone, I am quite confident that Justice Brandeis would not ask what James Madison thought about the use of a cell phone. I am equally confident that with regard to what Jeffrey had said with regard to big business, I think it is important that the power of big business in 1905 was not because they were providing substantial amounts of money to fund campaigns. The power of big business came because they were paying off legislators both directly and through patronage. That was the means by which big business, and there was enormous business. I mean, the names that were mentioned today are all museums in New York, Mellon, Guggenheim. There's a reason there's an enormous concentration of wealth, which we are once again reaching in this nation and this world, but it was a different form of control. Today, the form of control, fortunately, is not so much direct payoffs to politicians, and hopefully in many states not the direct use of patronage. It is the enormous power to control the airwaves through huge amounts of contributions and PACs.
I'd just like to respond to what you said about James Madison, and Justice Ginsburg made this point in passing, but I think it's a very important point, is that there is a very popular school of constitutional interpretation now called originalism, which means that the Constitution was frozen in amber in 1787, and we should just ask James Madison what he thinks about cell phones, and we'll have all the answers to our questions. I think both explicitly in terms of what Justice Brandeis wrote in his opinions, but also just the example of his life. He was not someone who believed the Constitution was frozen in amber. He was someone who believed that you had to, that all laws, including the Constitution, had to respond to what was going on in the real world at this moment. And I think, originalism is something that is discussed a great deal and in many respects more popular than it's ever been. Justice Brandeis is a wonderful recruit to the cause of a living Constitution, and someone who always spoke about how the Constitution had to respond to what was going on in the United States at the time.
Let me raise a slightly different take on some of the issues we've been talking about, and I think this may be the one that we'll each get a chance to talk about, and then we may have to call this part of the program to a conclusion, but this is a conversation that will go on throughout the semester, and I dare say throughout the next century. There will be those who will gather for the 200th anniversary. That's not our problem tonight. Justice Brandeis, before he is reborn as a libertarian on free expression, he and Justice Holmes are finding their footing, and they're actually in what we would call, most of us, the wrong side of the First Amendment cases, in a trio of cases in 1919, the Abrams case being the most famous, where the clear and present danger test is actually born as a justification for what we would call repression. Danger was found a little too clear and a little too present. He ultimately would be responsible for unpacking many of that and setting the seeds for a different, more progressive jurisprudence of free expression. But those cases in 1919 are in the context that is very present and speaks to us very directly today, that of threats to national security. Whether we thought those were real threats or not in 1919, there were those who felt they were real then, just as similar issues come up now. So what thoughts do any of you have, or each of you have, about how Justice Brandeis might speak to us today about the present role that issues of national security play in constitutional rights, both with respect to free speech, free expression, or privacy for that matter, rights to one's own information, one's own email, for example, as opposed to the government's right in protecting national security to invade some of those areas. Mark, I've never known you to hold back.
Well, I was trying, but
not an able effort.
A long pause. I think it's interesting that I don't know if everybody knows. Even I know exactly what you're talking about. But basically, seriously, toward the end of World War II, for World War I. People, often immigrants, were being prosecuted, for example, for advocating that others resist the draft. This is the real context of the case. And then the question is that criminal? Does it present a clear and present danger? Brandeis was very early in his career as a judge, as a justice at that time. And I wonder whether he would have come to the same decision maybe 15 years later. But the cautionary note for me is judges, when we get to areas of national security, there's a tendency, for good reasons, to give great deference to the executive. They have the competence, presumably they have the intelligence these days, but it's not a blank check. And I think even now, particularly 10 years ago, judges were victims of an effort to intimidate, as journalists were, as members of Congress were. You know, you're engaging in treason, you're endangering the nation if you try to limit the executive. And I think we judges should be reminded that even the most venerable of our predecessors, Oliver Wendell Holmes, Louis D. Brandeis, in retrospect, deferred too much. And that we should, while recognizing the importance of distinctions in the relative roles between the judiciary and the executive and Congress, when it comes to matters like speech, it comes to matters that are just fundamental to the operation of democracy, we shouldn't defer too much, even when there's great concern about threats to our nation or perceived existential threats.
I think it's been true throughout the history of the United States, and we have made some dreadful mistakes. Think of the internment of the Japanese Americans in World War II, a vast overreaction, and that wasn't even a law passed by Congress, it was an executive order. Big supporter was Earl Warren, and the Supreme Court got into the act later but said, yeah, it's okay.
I think there's an important exception to what Justice Ginsburg was pointing at, which was what the court did about Guantanamo. You know, at a time when there were, you know, deep and reasonable concern about terrorism in the United States and Al Qaeda, you know, really in the relatively immediate aftermath of 9/11, the Supreme Court on 3 occasions said to the Bush administration, on behalf of perhaps the most despised people on earth, the detainees in Guantanamo, said, you can't treat them that badly. And I think when you know, I never hesitate to be critical of the court, but I think, you know, when you look at how the court responded to national security crises in the past, whether it's World War I or World War II, the court really covered itself with glory when it came to the response after 9/11.
Ralph, you have the first word. You may get the last word. Please.
The discussion of Brandeis ties together Brandeis and Holmes, and they were good friends. And what is wonderful about your reference to the change in their vision of free speech is that it is a classic change in the originalism vision to an expanded vision. The original vision of the founders, I think, was that free speech meant only prior restraint. And that is what Holmes and Brandeis initially understood, that you can't prevent speech from being spoken through prior restraint, but it's okay to punish people who speak things you do not wish. And over the course of time, they observed how that in practice was being carried out. And it goes to Holmes's statement that the life of the law is not logic but experience. They experienced what the consequence was of that vision of the First Amendment, and over the course of time, especially when some of their friends were being punished for their speech, including friends at Harvard Law School, then their vision of what it meant to have a First Amendment changed. I think part of what occurs and part of what occurred at Guantanamo was a recognition of what the experience was of the absence of habeas corpus, because it turned out that for a fair number of those folks at Guantanamo, there was no there. And the experience of the risk of injustice was, I think, something that the U.S. Supreme Court, Justice Ginsburg would know better, recognized as demonstrating the importance of having some legal recourse in a court for what may be an abuse of power.
Philip, last word.
I think, if I just may, one thing, I think we ought to change the question a little bit. I think we really can't answer the question of what would Brandeis say, but I think we can answer the question of what principles guided Brandeis and how do we apply those to the problems that we're looking at today. Then I think we can learn a lot from her.
And
Well,
I think
it's-
one of the things that has come through all of our discussion is the freshness. I know she's behind me. I got pretty good vision back there.
We've been doing this for years, so.
There's a freshness to Brandeis. With all due respect to Oliver Wendell Holmes, sometimes one feels when one reads Holmes, one is taking a trip to the Jurisprudence Museum. With Brandeis, one never has that feeling. There is a freshness that continues to speak to us. We each have a favorite Brandeis quote. I'm sure most of us have many, but one of my favorites associated with this campus is Brandeis, who challenged us when he said, if we are to be guided by the light of reason, we must let our minds be bold. And I think he meant that not in a light way at all, and he understood that to let our minds be bold is a challenging and sometimes uncomfortable exercise. It is willing to go places that we're not sure that we're comfortable going. He understood that better than just about anyone, being born at the Civil War and living all the way through the Second World War. We have launched an important discussion of letting our minds be bold. My fellow panelists who have done a splendid job at keeping us led by the light of reason. Thank you. Madam Interim President.
Thank you, Fred. That was a wonderful way to bring this fascinating discussion to a close. Ladies and gentlemen, this concludes our program. I have one request for you. If you could please remain in your seats until the panel has left the stage. But in the meanwhile, join me now in another round of applause for Justice Ginsburg and our distinguished panel.
Well done. And I think you set it up beautifully. I think raising the issue of the Brandeis brief in that context is very thought-provoking.